And I call the member for Solomon.
Thank you, Mr Deputy Speaker. I rise to speak on the Corporations Amendment Future of Financial Advice Bill 2011 and the Corporations Amendment Further Future of Financial Advice Measures Bill 2011. These bills seek to introduce a framework for financial advisors to ensure they provide Australians with accessible and affordable financial services and advice. The purpose of these bills is to require those persons who are providing personal financial advice to retail clients to act in their best interests of their clients and to give priority to their clients' interests. In addition, the bill applies existing regulatory mechanisms under the Corporations Act in a more direct manner to individual advisors as well as to licensees. Furthermore, the bill seeks to amend the Corporations Act to enact a ban on the payment and receipt of certain remuneration by those persons providing financial advice where a potential to influence that advice exists resulting from certain financial products. There are two bills making amendments to the Corporations Act to implement the FOFA reforms announced by the government in 2010. The first is the Corporations Amendment FOFA Bill, which was introduced in the Parliament in October 2011. Back in February 2009, the Parliament asked the Parliamentary Joint Committee on Corporations and Financial Services to conduct a comprehensive inquiry into the Australian financial products and services, following a number of high-profile corporate collapses such as Storm Financial, Trio and Opes Prime. The first bill seeks to improve the disclosure requirements in respect of fees and services connected with the provision of ongoing financial advice. Additionally, the bills seek to strengthen the powers of ASIC pertaining to financial advisors. Furthermore, the bill seeks to put in place new obligations on financial advisors, which is that they are to act in the best interest of their retail clients and to put a future ban on conflicted remuneration structures. The Parliamentary Joint Committee on Corporations and Financial Services reported on these bills back on the 29th of Feb 2012. In a dissenting report, coalition members of the committee discovered that Labor's FOFA proposals will unnecessarily increase red tape and the cost of financial advice and will reduce consumer choice and competition if passed in their current form. Coalition members of the Parliamentary Joint Committee concluded that the FOFA bill in its current form is unnecessarily complex and unclear. Mr Deputy Speaker, the financial and advice industry is the provider of value products in terms of service which helps Australians to manage their financial health and well-being. Financial advisors assist by helping Australians through the mire of financial risk and seek to maximise financial opportunities. In reality, they deal with other people's money, which is why any changes in the financial and advice industry must be supported by an appropriately robust regulatory framework. However, we, the Parliament, must be mindful of the need for change to improve the existing landscapes, not change which makes industry more complex and costly for all involved. The financial advice industry in the Northern Territory is no less than anywhere else in this wide brown land. More and more, the average Territorian is required to seek out the services of this sector, necessary to manage and obtain the very best long-term advantage for the management of their own futures. Home loans, insurance and super, all basic commodities in this day and age, which most of us just assume are provided with our best interests at heart. From my own experience, I am by no means full bottle on all the products that I currently use. I rely upon services and exponents of the financial services sector to steer me in the right direction and keep me on the correct path. and I have a background in business and am familiar with the financial systems. So sadly, I can say I have learnt the hard way about conflicted remuneration structures. If with some level of business acumen I have difficulty, then how is the average person expected to understand without the assistance of exponents with the financial services industry? The review undertaken by the Parliamentary Joint Committee on Corporations and Financial Services, or simply the Ripoll inquiry, made a raft of well-considered and reasonable reform recommendations, providing a blueprint for the government to move forward. However, over the ensuing 2 years, the value of these recommendations has been uncertain and clear direction has been lost. As a result, we find the bills currently being debated here today as a piecemeal offering and unless amended, untenable legislation which would seek to increase costs and red tape for both business and the consumer. Mr Speaker, it is disappointing that such delays have occurred, particularly for an industry that has such an important function to perform within our society. As it currently stands, the legislation has the potential to reduce consumer choice and competition if approved in its current form. The Coalition cannot support the FOFA bills in their current form. Therefore, the Coalition, the Coalition amendments express purpose of addressing some of the current flaws. Our initiatives include a recommendation that the Parliament be resolute on the preparation of proper regulatory impact statements that comply with the government's own best practice regulation requirements. The RIS must be compliant with the government's Office of Best Practice Regulations and be tabled in the Parliament before the legislation could be further considered. The Coalition would also recommend removing the government's opt-in proposal. This addition is outside the recommendations of the Ripoll inquiry and proposes to impose a mandatory requirement for all consumers to re-sign contracts with their financial advisors on a regular basis, a measure that has the likely results of significantly increasing the red tape and costs for both the planners and the consumers. The Coalition also recommends an amendment to the current draft of the bill relating to the best interest duty to improve clarity and certainty about its application. Further, inclusion of this measure in the Corporations Act is supported, but this must occur following the correct drafting and clarity of words necessary to remove any confusion and ensure understanding. Section 96B 2 of the bill defines a set of comprehensive steps designed to provide guidance to advisors, yet Part 2G of the same section allows for any other steps that would be reasonably be regarded as being in the best interest of the client. We believe that if other steps exist, then they should be included in the legislation, not left as a point of confusion or misinterpretation. Without change, this amendment creates uncertainty that will result in test cases before the courts. The Coalition also recommends the removal of the retrospective fee disclosure statements. There was no reference to this in the Ripoll inquiry that recommends the introduction of an additional annual fee over and above the current regular statements already provided by the financial service providers to their clients. The Coalition concludes in this instance that retrospective fee disclosure adds no additional consumer protection benefit and will introduce further increased costs, ultimately costs that will be passed on to the consumer. It's estimated by the Financial Services Council an implementation cost of around $700 million. The Council have suggested that the cost per client for fee disclosure would be halved if only if it only involves new clients and summary information. Inevitably, any costs associated with the implementation of any amendments will be passed on to consumers. The current piecemeal approach is yet another example of the very poor consultation process engaged by this Labor government. What started out in such a positive manner has devolved to a point where, unless further amendments are made, this suite of proposed changes cannot be supported. In terms of superannuation, the Coalition recommends, until further refinements are made, a ban of commissions on risk insurance inside super should be in place. The Coalition Committee members support the banning of conflicted remuneration structures, for example, product commissions with the financial services industry, and we praise the industry for taking a proactive stance to abolish such conflicted remuneration structures. However, it's our stance that commissions paid on advised risk insurance, be they the group policies or individual policies inside or outside superannuations, are conflicted remuneration structures. Banning commissions in this instance has the potential to increase costs for consumers. It can remove choice and leave many people worse off, especially small business people who self-manage their super. We, the Coalition, further recommend the implementation of FOFA be delayed from its current due date of the 1st of July 2012 to the 1st of July 2013. The existing timeframe of now 4 months is manifestly inappropriate and untenable for the industry. Projecting the commencement date for any changes to the 1st of July 2013, or at the very least legislating an introductory timeframe to give the industry the opportunity to implement change over the comparable timeframe, is paramount. This date also aligns change with the proposed MySuper. It would make sense to implement FOFA and MySuper simultaneously. FOFA involves significant and expensive changes that would result in large changes to IT systems and advisor training. Rushing the implementation and putting pressure on the industry to act will result in mistakes and inefficiency, which longer term will result in extra costs, which will ultimately be borne by the customer. So we therefore commend to the government that to overcome the potential difficulties with adhering to a manifestly inadequate timeframe, that this bill, once amended, should not commence until the 1st of July 2013. I've received correspondence, by many other colleagues, from our constituents. So the calls that I've received, correspondence and calls from practitioners within the financial advisory sector over the past few weeks. The call from each and every one has been the same. This legislation has fundamental support in terms of its intent, that is to improve the level of transparency within the sector and to further broaden access to financial services. However, in its current form and without critical amendments, those in the industry that have contacted me do not support the bill. I've been reminded as a result of these contacts, the Prime Minister is on the record as saying a key priority for her government is to slash red tape. Need I say any more? We know she doesn't have a good track record with keeping her promises. This bill, however, will see added complexities, paperwork and red tape to the sector, ultimately resulting in increased costs which we passed on to the consumer. In conclusion, Mr Deputy Speaker, the Coalition agrees to move amendments to the Corporations Amendments Future Financial Advice Bill 2011 and the Corporations Amendment Further Future Financial Advice Measures consistent with the 16 recommendations made in the dissenting report of the Coalition members of the Parliamentary Joint Committee on Corporations and Financial Services. We oppose the Corporations Amendment Future Financial Advice Bill 2011 and the Corporations Amendment Further Future of Financial Advice Measures Bill 2011 if these amendments are not carried. Thank you,
Thank the
Mr
member for
Deputy
Solomon.
Speaker.